Hi, so I'm Sarah. I'm not sure who I've sent out the link that I had to multiple people. So if you've added with a link that I sent you directly, it might be worth changing your name. Otherwise, you will just come up as me. Um, I work for Latin Elephant, and I just want to say thank you, first of all, for coming. Latin Elephant and a bunch of other groups, many of whom are here, are part of a coalition of campaign groups from across London that are working to stop gentrification of local retail spaces. And we know from lots of conversations with the traders in all of our communities that finding legal support and specifically around commercial leases is really, really difficult. And so we are putting on this workshop with PILK and with Landmark in order to try to answer some of your questions. So I'm going to introduce Alex and Harley, who are from Landmark, and also would just want to say thank you to Saskia and to Alex, who are, you might see their names say PILK on them, which is Public Interest Law Center, and to say thank you so much for coming. If Alex, you'd like to start, or if Saskia, you'd like to say something, please feel free to.
Yeah, I'll say just one word, which is, again, a massive thanks to Landmark for coming in and speaking today. Again, myself and my colleague Alex totally appreciate that it is really tough for market traders to access the law and to access legal advice. So this hopefully will go some way in remedying that situation. But yeah, just to say that, this has come out of a conversation that we had with Sarah, this idea, and we're just really happy that it's happening now. So I hope everyone gets something out of it and it's getting recorded. Yeah, that's all. Over to you, Alex.
Great, thanks, Saskia, and hi everyone. So I'm a barrister at Landmark Chambers with my colleague Harley. I'll be covering one and a half, possibly one and a third topics. Firstly, the law around consultation, and then a brief introduction, oh so brief, to leases, tenancies, all the hard property stuff, and I'll leave it to Harley to go into more detail on business tenancies, how to deal with breaches of contracts. He has a PhD in property law, so he really is the expert. And we will be able to share the slides, so no need to take notes. And apologies in advance, there will be quite a lot of information coming your way in the next hour or so. So any questions at the end, no problem at all. So consultation first, or lack thereof. This often comes up when there are plans to quote unquote regenerate an area in a way that may well affect your businesses. And the local authority will draw up a series of options usually, and then usually they'll do one or two or more rounds of consultation. Often, and you may have experienced this yourself, they do have a pretty firm idea of what they think the right answer is. And sometimes it's apt to say the consultation is only a formality from their point of view. They know what they're going to do and they're set on doing it. But it really shouldn't be like that. There are several legal requirements a local authority or other public body need to go through, need to follow when consulting with people like yourselves and those you represent who are affected by their plans. And if they get the law wrong, if they don't follow the requirements for a lawful consultation, you can challenge them in court and potentially slow the whole process down, which is, of course, beneficial if you don't agree with what they're doing. There's a saying in public law, you can't stop the man, but you can slow him down. And if you slow him down enough, he might change his mind or his focus, might go elsewhere, and then you're safe for a bit longer. So it's always worth thinking about using the law for that purpose. A consultation does mean. We have a quote here from a judge in typical judgy language, a case called Medway from over 20 years ago. What does he say? Consultation is not negotiation, it's a process within which a decision maker at a formative stage in the decision-making process invites representations on one or more possible courses of action. And yes, people in my profession do speak like this quite often. He then goes on to say, in the words of Lord Wolfe, the decision maker's obligation is to let those who have potential interest in the subject matter know in clear terms what the proposal is, why it's under consideration, and telling them enough to enable them to make an intelligent response. So already we're starting to see in that quotation some of the requirements for a lawful consultation. The person who is doing the consulting needs to give you, the consultee, enough information for an intelligent response, for example. More on that later. When will a duty to consult arise? Importantly, there's no general legal duty for public bodies, local authorities to consult you or anyone else before making decisions. No general legal duty. Slight caveat there, before granting planning permission for a redevelopment or exercising compulsory purchase powers, there does need to be a consultation. But that's because various laws say that there must be a consultation. There isn't a general right to it. If your council decides to do something that affects your business, unless there's a specific law telling the council that it needs to consult you, then it probably doesn't need to consult you. There are, as we see on the slide, other circumstances. There may be an obligation to consult arising from a promise. I promise to consult you on any redevelopment of your market in the future. 3 years later, they don't. You might be able to take them to court and say, you promised 3 years ago that you would consult us before you did anything of this nature. Although I did lose a case where the government promised to reconsult on something and they didn't, but then the government just said, well, COVID, of course. And the judge said, of course, COVID, and we lost, but which was annoying because usually promises to consult, judges say that they should be kept, but it's okay. 4 years later, I'm not bitter about it or anything. I don't mention it at every opportunity. Other circumstances, it may be conspicuously unfair. Love that language, conspicuously unfair, very legal language. Conspicuously unfair to make a decision without first consulting. A judge once called my submissions unduly tendentious once. I had to look up what that meant. It means partisan. I'll take it. Next slide, we have another point. If they decide to consult you, the council or another public body, the government, say, they have to do it properly. They can't do half a job just because, strictly speaking, they don't need to consult you. So that's another important point. If you receive a consultation document from your council or another public body, then it's got to follow all the legal requirements. What are those legal requirements? Well, they crystallize in a case called Gunning in 1985, which was about a school closure and an inadequate consultation on that. And their 4 principles were set out. The consultation must be at a time where the proposals are still at a formative stage. That means if the person consulting you can't have already made up their mind, otherwise it's not a consultation, it's just information they are going to have this redevelopment, for example. Secondly, the proposer must give sufficient reasons for any proposal to permit intelligent consideration and response. So they need to give you enough information to be able to respond effectively to the consultation. Thirdly, you need adequate time to give your view to them. If they only give you 48 hours or 7 days and it's very complicated, then you may response to the consultation. And fourthly, lastly, basically, they have to properly take into account what you've said, although they don't necessarily need to agree with you. A lot of judges really like this formulation of the legal requirements, and so they've been repeated in lots of legal cases, and it's basically the set law on consultation now, those principles. So let's go through them in a little bit more detail. Principle 1, you need to be consulted before the decision is made. They can still have preferred options, though. That's okay, that's lawful. They just need to be, I'll say, amenable to persuasion. They just need to have an open mind. You can present another option to them as long as they're prepared to listen to it, properly consider it, then they're fine. They don't need to consult on every option. That's important, although they may well need to give enough information to explain that on your preferred option. That brings us into requirements, sufficient information. It's no good being consulted on a proposal, say a regeneration proposal, that you don't and can't reasonably understand because it hasn't been explained to you how they've reached a certain number of options or what the redevelopment plans actually are, what the changes to the local business layout, etc. are. And also, if they have a preferred option, you also need to know what that preferred option is and why it's that preferred option, because you may have a better idea as to what should happen in your area. And you need to be able to, you need the opportunity to persuade them otherwise. Principle 3, you need to be given sufficient time to respond to the consultation. If they bomb you with a lot of new information, as I may be doing now, obviously you need time to consider it. It's an important decision that might affect your livelihood. Obviously, you need time to consider it and take advice and produce the best possible consultation response that you can. So the bigger the decision, the more complex the decision, the more time you need to be able to give the decision maker your view on what should happen, whether you like that proposal or not, how you think it should change. Principle 4, there's no point having a consultation, there's no point asking for consultation responses if they put them straight in the bin without looking at them. So they need to actually consider conscientiously what you say, what your views are. They're in trouble. So final point on consultation. When is there a duty to consult, to reconsult when they've already done a consultation? So they might do one consultation, they might have done two. When do they need to do another one if you're unhappy with how they considered the previous consultation? And basically, to establish a duty to reconsult, you have to show that there's been a fundamental change in the factual circumstances such that it would be unfair if they didn't reconsult you. So let's say they consult on a big pile of documents, but then they reach that decision on the basis of a newer big pile of documents. You may need to be reconsulted on those new documents if there's been some new assessments of the impact on the local area of the, again, I'm just using the regeneration scheme example because it comes up a lot, but actually any form of consultation could be a public library closure, could be a school closure, could be changing opening hours, etc. So those are the principles. Tying them all together, I have on this slide a case study And we'll see in this example, consultee, person being consulted, is a market trader, and the local authority set the opening hours for the market stalls, currently 9:30 to 5 p.m. every day. And then you, the market trader, get this letter, which reads, the local authority have received numerous complaints about weekend noise. We've carried out a full impact assessment and based on its findings have decided to limit weekend opening hours to 10 a.m. to 3 p.m. If you have any comments on this, please respond to this address within 7 working days. Now, immediately, you can see a number of problems with this alleged consultation. As you can see on the slide there, I'd like to think or hope that there never would be a consultation like this from a local authority, but I've perhaps become pessimistic in my old age, and it's quite possible you may get something like this, or almost. But as you'll see, very little information. What is this impact assessment? What were its findings? What did it say? Why have I only got 7 days to respond to this consultation? And also, it sounds like you've already made your mind up. So why are you even asking me? So highly likely to be unlawful, that one. So if you do get something like that, or something that, might be half as bad as that, speak to Alex and Saskia at Public Interest Law Centre, go to the High Court to do it properly. Now that's consultation. I'll now go on to rights of occupation. And as I said, I'll give you the basics, and then I'll hand over to Harley, the property law mastermind. There are a number of ways you might be occupying your shop, your stall, whatever it may be. You may own it outright. You might be leasing it somehow, formally, informally. You might just have a license to occupy. And given how arcane property law is, there are probably 3 or 4 other ways you could be occupying it, but those are the basics, what I would say the most common or main ways you could be occupying your spot. What does all this mean? An excellent question. Let's find out together. Freehold owner. This is the top tier of property ownership. The end of the board. You own the means of production. Congratulations. And you might think, as a shop owner, owning the freehold, all your worries will be over. You own your own patch of land. That's great. But sadly, certainly my experience of my clients, that's not the case, particularly with large regeneration schemes. I saw this in a case in Tottenham. My client was a fast food shop in the freehold. But the plan is, as part of this regeneration scheme, the developer will, via compulsory purchase, buy up all of the local business owners' land, convert half of it into student accommodation, quids in, and then offer up only leases of the remaining half to all the owners who have just been kicked out, so they won't get their freeholds back. And if it all goes to plan, they can do that, no problem. To the law, they can. So it can still be a little bit dire, even when you are a freeholder. But I suspect, as market traders, most of you will be having leases or licenses. And let's go into what those are. A lease is basically a sort of legal situation where you don't own the land, but you rent it out. So you have a landlord, and you have a contract with a landlord that will entitle you to what's called exclusive possession of the land. So lease is just a contract, written or verbal agreement, doesn't have to be written down if it's a short one. And again, exclusive possession. You rent, you get the spot, and you can prevent anyone else from using that spot, including the landlord. That's all that's meant by exclusive possession. If your landlord has a right to use that land alongside you, for example, then it may not be a lease. There's a few caveats there, in that a lot of leases contain, rights to access for maintenance, for example. But generally speaking, if it's your plot and you can do what you want with it and exclude other people, it's likely to be a lease. There are different types of leases though, and it will be well worth trying to work out what type you've got, because it'll affect your legal rights. It could be a tenancy at will, what's called. This is the weakest kind of, I would say, because your landlord can cancel it, nullify it at any time. So you're in a precarious spot if you have one of those. But don't despair. There is often a debate to be had as to whether you actually do have a tenancy at will, even if it's called a tenancy at will. Because if you're paying regular rent payments, then you may well instead have a periodic tenancy, which we'll go into, but that's much stronger. Because if you're a business owner with a periodic tenancy, the landlord can only kick you out under limited circumstances, as Harley will explain. As to what a periodic tenancy is, again, you need a right to exclusive possession. You need to pay rent for this one. Could be weekly, could be monthly, could be yearly. And essentially the lease continues from term to term. But if that's the situation you have, even if it's it will, as I've said, well worth seeking legal advice. The law on this is fiendishly complicated. So if there's a Q&A on this, I won't be able to give you an answer on the spot. But just because the landlord says you got one thing doesn't mean you have it. And if you got something else, then you may have more protection than you realise. You, of course, also have fixed term tenancy, the sort of thing we see in the, I say domestic sphere, that's probably the wrong way of putting it. But if you've got a landlord, as I do, then you'll be on a fixed term tenancy. Could be 3 years or 5 years or whatever. And as Harley will explain, if you're a business tenant, then again, you get some important protection from eviction with this kind of lease as well. Finally, you may not lease though, you may just have a license to occupy. Different types of licenses, but the main ones are bear licenses, they're called, not a license to hunt bears, but a simple agreement that you can temporarily use the land. That's the first one. So when the postie delivers the post, he or she is not trespassing on your doormat because they have an implied license from you to be there. You've not granted them the right to sit on your doormat and prevent you from leaving, for example. Don't know why it keeps happening to me. But it shouldn't, no lease, just a license that can, again, a precarious position to be in, and ideally you'd want a fixed lease if you could negotiate one. Importantly as well, if you just have a license, the license is between you and the landlord. So if the landlord sells up, if the freehold of the building or the plot of land changes, the license you had with the previous owner will not bind the new owner as well. So another reason why it's worth trying to get a lease, because if you've only got a license, property ownership at the higher level changes quite rapidly, and someone may buy up a market area, for example, having been told that the market stall owners have only got licenses, and then they may try and kick everyone out. So again, another reason why lease is better if you can get it. As to how you negotiate that kind of stuff, I'm now going to hand over to Harley, who's also going to explain a bit more detail what this protection is that you get from having a business tenancy, a business lease.